Hi, everyone. My guest today is Raoul Parekh. Raoul is a partner in the London office of Littler, the largest global employment law firm. Raoul specializes in helping multinational companies solve employment law problems. He co-leads London office's international practice and has a particular focus on classification issues and employers of record. Raoul is recognized as a leading practitioner in Chambers and Partners 2024 and in International Employment Lawyers IEL Elite. So we're very delighted to have Raoul on the podcast today. Welcome, Raoul.
Thanks, George. Great to be here.
Excellent. Well, look, I'm really excited to be speaking to you today. The focus of today's conversation is all around employee classification and contractor misclassification. We're going to be talking about things like how to correctly identify employees versus contractors and global problems faced by global companies. So I guess to kick things off, how would you define contractor misclassification and why is it a big deal?
So George, contractor misclassification basically refers to companies and individuals declaring that the relationship between them is not an employment relationship, i.e., that the contractors are self-employed, when the law of the relevant country where the contractor is operating says otherwise. So, at its simplest, it involves the company and the contractor signing a piece of paper that says they're not an employee when the law of the land says that they are. You also asked, why is it a big deal? And I think the first thing to say about that is that actually sometimes it isn't. A lot of the time, the mistakes that companies and individuals make about classification just never come to light. So it's not a big deal. And it never even, no one ever knows. For example, let's say that you hire a would-be contractor. The individual makes proper tax declarations. The company's got a solid agreement to protect themselves. Maybe it's for a particular project, a particular piece of work. At the end of the relationship, company and contractor need to go their separate ways. Then in all likelihood, the arrangement will never come to the attention of any court, any regulator, any lawyer. It will be a happy ending. But obviously, not all stories do have happy endings, and sometimes these things do come to people's attention. And probably the most common time when it comes up is at the termination of the relationship. On the way in, everyone's happy, more or less, to sign the piece of paper they're being given to say that they're not a contractor when they're not an employee when perhaps the law of the land says that they are. But then when you get to termination and the company wants to end the relationship perhaps, but the contractor doesn't, that's when the contractor might see an advantage in their position to asserting that they are an employee. Because one of the consequences of being an employee in most countries around the world is that you have some degree of protection from termination. Whereas, of course, if you're a contractor, it's a business-to-business relationship, and your only protection is the terms of the contract, which might say the company can terminate 10 days' notice or even no notice. And when that happens, when the issue does crystallize, when the sort of chickens come home to roost, the issues that companies can face in that situation include tax issues, where they should have been deducting payroll taxes from the amounts they were paying to the would-be contractor. There can be termination costs. We talked about termination protection, and that can mean that the company is due to pay a certain amount to the contractor when they terminate their employment. There can be pension liabilities. Like in the UK, you have to auto-enroll employees in pensions, in a workplace pension. Doesn't apply to contractors. And there could be other claims like discrimination, for example, where employees will, in pretty much all countries, be protected. Contractors, to varying degrees, generally won't. And it can even lead to the steps where, to the extent that termination is sort of difficult or impossible, because the contractor might be entitled, if they are an employee, to be reinstated into their previous role. So as a company, you think you've terminated the relationship, you think you've said goodbye, you don't just get sued, you don't just have a back tax liability, you also have got the person back that you wanted shot of in the first place. So that's the worst case scenario, and that's really why it makes sense to have a podcast and talk about these things.
Yeah, in fact, that final point I'd never even come across myself. I didn't even realize that was possible. But I guess that depends on the situation. But just to summarize, it sounds like sometimes this isn't a big deal, sometimes this is a big deal. it's typically at the end of the relationship when it kind of rears its head, and that can have a lot of different consequences associated to it. Does that sound about right?
Right. I think the end of the relationship tends to be when the contractors sort of see the reason to push it. That can occur at other times when sort of adverse changes are being made, for example, but generally it's at the end.
Yeah, got you. And I think one thing that I'm starting to see a lot here is that like different countries have different approaches, and in your mind, is it quite black and white? Like this person's a contractor, this person an employee, or do you often see blurred lines here?
No, this is definitely an area of the law that is full of grey. So there are tests, there are factors, but you can speak to two different employment lawyers, get two different answers about whether a particular person is more properly categorized as an employee or a contractor. So this stuff isn't easy. And that's why there are laws about it. That's why there are cases about it. And that's why there are disputes. But just because it's difficult, it doesn't mean you should ignore it. Kind of means the opposite. It means you have to pay attention and get into some of the detail if you're going to manage the risk for your business.
Yeah, got you. So yeah, definitely can be a grey area. Definitely look to take some advice. Sounds like a clear message there. What about in instances where you might see that actually there's an international employee, you don't have a business entity there in that country, so you end up like kind of de facto employing them as a contractor as opposed to a full-time employee? What would your kind of
Yeah, I mean that is a very classic fact pattern that you described. It's a common situation that you have. You might get on the phone to a new client, been introduced to you, says maybe they're an international business and they've found their perfect CTO or chief marketing officer or whoever it might be, but they're in, let's say, Cyprus, where the client has no business, no particular plans to have a business. Their only interest in that country is that their perfect hire is there. And that can make hiring that person quite challenging. In pretty much every country in the world, you're employed or you're self-employed. Sometimes there's a little bit more complexity than that, but generally it comes down to those two categories. So you've got to choose. Are you going to employ this person? If you're going to do that, generally you'll need a legal entity, not always. If you don't need a legal entity, what you'll need anyway, or if you do, you'll need to set yourself up to deduct taxes and pay them over to the local taxing authority. You'll need a payroll agent. You'll need a locally compliant employment contract and so on. So that can feel quite unattractive. In comparison to that, the contractor option can be quite seductive. All you need is a contractor agreement that might find off the internet, or certainly a lawyer will give you for not very much money. And sometimes the candidate will be quite enthusiastic about that option too, because they might perceive that being a contractor carries a tax advantage. Whether it does or doesn't varies quite significantly from country to country, and often people perceive it as having an advantage and really it doesn't. But it can feel, as the sort of advisor, or whether it's an HR professional or lawyer in the room there, you can feel like you're kind of breaking up the party. The company's happy to hire them as a contractor. The candidate's happy to be engaged as a contractor. Why are we saying that they shouldn't? But the reason, of course, is some of that stuff we were talking about a little while ago, the potential when it goes wrong. Now, of course, there is also another option when you're focusing on employment to what I described, not to the legal entity setup point. And that's using something like an employer of record as a solution, obviously something Omnipresent does and other providers. And what that can do is it can mean that you've got something approaching the ease of the contractor solution that attracted you there, because you're not having to take on all of this administrative burden of basically setting yourself up to be an employer in a country where there's just one person you want to employ. But it comes obviously at a cost, because any employer of record, I'm sure it's the same, will want a fee for the service they provide. But it can provide a valuable sort of third way that avoids the classification risk, because the CTO in our example is now an employee of Omnipresent, but also avoids the administration because the employer of record is handling that for you.
Yeah, absolutely. I think given kind of some of the risks you mentioned a bit earlier on, like finding a contractor agreement online feels like a very simple
Yeah.
solution, but you don't know what you might be sleepwalking into there, right? So Google certainly, or ChatGPT might not be your best friend in some of these. So
Yeah, exactly. Maybe one day, but not
yeah.
quite yet.
And another thing that kind of sprung to mind is you mentioned kind of, you find a CTO in Cyprus that you think is a really good person. But my understanding is like different countries are going to have different perspectives on some of these things. Certain countries might be a bit more lenient. They might not be quite as demanding when it comes to classification, whereas other countries might come down a lot harder on you. What's your take on kind of navigating some of those complexities?
Yeah, so yeah, you're 100% right, George. Each country has different laws and different rules, and even within the EU, this isn't an area where there's harmonisation across the member states. So, it's a matter of national law, and obviously countries outside the EU as well have their own national laws. What's surprising from having done a lot of sort of global classification projects is actually the degree of consistency once you get into the detail. So the same factors will keep coming up again and again when you talk to lawyers in particular countries about what makes an employee and what makes a genuine self-employed contractor. Things like taking on financial risk, or the employer not exercising control in how the work is performed, payment by results instead of by time, the ability for the contractor to send someone else on their behalf to do the work or outsource it to their own employees. If you asked lawyers from 50 different countries what makes an employer, what makes a contractor, there'd be a very big overlap in the middle of the Venn diagram of the factors that they describe. The differences tend to come in how those factors are weighted. So, for example, in the UK, the ability for an individual to not be required to do the work themselves and have the ability to send a substitute is particularly important. And in other countries have their own particular focuses. There's more in common than they have difference. But the other area where things do diverge more dramatically is on enforcement and consequences of misclassification. So, for example, some countries will have quite a regulator-led enforcement approach where agencies will seek out these misclassified, as they see it, employees, maybe even bring claims on their behalf, or sort of levy fines against companies who are engaging these contractors. In other places, again, like the UK, for example, that is largely unheard of, and it's up to the individual contractors, would-be employees, to bring the claims. So that can make a significant difference to the practical risk that a country might face, even in two countries where the rules on paper look pretty similar.
Yeah, that makes total sense. It sounds like there's some common themes about financial risk and being able to outsource work and what control you have, but like you say, like there might be certain countries that really are very stringent on this, whereas others are a bit looser. I'm curious though about the worker's perspective on this, because for some, I guess it might seem like a really simple, okay, I'll just sign this contract, I get to work for this company that I want to work for, and a really quick and easy way to get going. But how might that not be in their best interest?
Yeah, well, I mean, of course, the whole reason why countries have these laws which attempt to draw this bright line between employee and the self-employed is because of what goes along with employee status, all of the protections and benefits that countries give to employees, which obviously differs significantly across country. It's going to be a very different picture of employee protection as an employee in, say, Texas compared to an employee in France, or even an employee in California. So what protection you get differs a lot, or what benefits you get. The fact that there is something there doesn't. So diving into that in a bit more detail, I mentioned earlier on when we were talking about protection from dismissal, that's a really big one. Again, not something that most people think about on their way into a relationship with a new employer or new client, as it were. But sadly, most work relationships come to an end, and it's at that point that protection from dismissal can be really important. And again, can vary a lot from in the UK, where you have protection from unfair dismissal at the moment when you get to 2 years service, something likely to change under the Labour government, um, and to in the US where there's very little protection from dismissal because they have at will employment, and then other places like France where you maybe an even higher level of protection than the UK. Another big point is social security contributions. So, firstly, they can obviously be quite significant and expensive for the company, but also having those contributions made on your behalf can be very important to your entitlement to future benefits as an employee versus a self-employed contractor. We also mentioned pension earlier, which again can be quite a valuable benefit as an employee. Maybe it's 5, maybe it's 10% of salary going into your pension that you're just not going to get as a contractor. Another big one that hits more day to day is paid holiday, which is an entitlement across the EU, in the UK, and in most countries in the world for employees only. So some things will hit from day one, and then probably another bucket is related to time off work. So things like paid maternity leave, paid family leave, they will only be available to employees. So there is quite a big bucket really of protections that have built up over time, I'd say, as the employment landscape evolves in each country, that is, generally speaking, only available to this protected class of employees. So if you're not identified as being in that class from the outset of the relationship, at some point, if you want to get those benefits, it's going to be a fight.
Yeah, it makes a lot of sense. There's one other instance that I might throw in the mix as well. So putting my hiring manager hat on, I was interviewing somebody a couple of months ago, and they were hired as a contractor for another company, and they hadn't been paid for like 2 or 3 months, and feels to me like it would be much easier for them to like actually go and claim something back if they weren't hired as a contractor. If they were an employee, right, and have much more sound legal grounding to go and to do something about it.
Yeah, that's a really good example. So in the UK, for example, if an employee hasn't been paid, they can bring a claim for free in the employment tribunal for unlawful deduction from wages. On the other hand, if a contractor hasn't been paid, that's a breach of contract claim that you need to bring on money online in the county court, like suing your builder for doing your bathroom wrong. And it's not an impossible process, but it's more painful and a little bit more difficult. In other countries, it goes further than that, and not paying employees can lead to what they call pocket penalties. Fines that are levied on the employer for failing to pay employees on time, which can very significantly increase the risk for an employer of not paying their employees on time compared to a contractor. So I think what you've put your finger on there is like another example, one of those employee protections, employee entitlements that, in your example, your candidate had been outside of the tent, and if you had been in, it would have been a different picture.
Yeah, absolutely. I'm curious to get your take on something else, though. Do you see use of contractors being more prevalent in certain industries or in certain kind of marketplaces? What are you seeing?
Yeah, I mean, I think to some extent this is a universal issue. It does affect lots. Like most industries will have some use of contractors to some degree that will be legitimate. Some it might not if push came to shove. The two places I'd say it comes up more than the average are, first really obvious one, the platform economy or gig economy, where taxi drivers, delivery couriers, other people working in that sector are not classified as employees, and where there've been a series of cases about that we can get into in a bit more depth if we want to. But that's an obvious one, and they've made the law in a lot of countries in this area in recent years. I think the other is the tech sector, because for a few reasons. One is, I think, and not to stereotype, I think you get a lot of people wanting to get things done fast and being a little bit impatient with sort of compliance, particularly in a startup culture. So that maybe drives people to take that seductive choice that we were talking about earlier of the easy contractor agreement from Google versus, having to deal with delays like payroll. But the other reason is, I think, that it's quite common for the search for talent in tech to take you to places that you places outside your own borders, which makes employment more difficult and makes contracting sometimes seem like the only option. Um, and finally, I think as well, there's something about the particularly in the sort of coding side or the more technical side of tech hires you might be making. People are often the candidates are quite keen for it, and the candidates can be often legitimately contractors because they are working across a portfolio of multiple clients on a project basis. So it's not necessarily to say that tech is a hub of misclassification so much as to say tech makes big use of legitimate use of contractors as well. And then obviously that creates a bit of a fuzzy zone in the middle between their also large employee bases.
Yeah, absolutely. I think you touched on a few different points there. Interestingly, I was in Barcelona at the weekend. For my daughter had a cheerleading competition. Slightly off topic, but it's like going around Barcelona. Like, everywhere is Glovo is like the Deliveroo of Barcelona.
Mm.
The Deliveroo drivers around London. You see them over there in the same numbers. I read something about 18 months or so ago about them having some fines and having some difficulty about classifying contractors.
Yeah, and that's an example of one of the things I was sort of alluding to there, an instance of the gig economy fighting in it. It sounds in that instance losing a misclassification case, and it's something that we've seen in lots and lots of countries in Europe, in lots and lots of different sort of segments of the platform economy. So the probably the most heavily publicized one here in the UK was the Uber drivers who went up to the Supreme Court on classification. Actually, strictly speaking, not about whether they were employees or not. That was not an issue there. It was about whether they were part of a different sort of subcategory under UK law. But it got a lot of publicity. And then in other countries, we've also seen decisions going actually in both directions. Spain has been quite more radical in this area, has introduced new laws that make the environment more difficult for the platform economy in general. But other countries have seen decisions go in the platform's direction as well as others that have gone the other way. So it is something that I know that those platforms pay close attention to and think quite deeply about. There's also some upcoming legislation, the EU Platform Workers Directive, which is just in the process of coming into effect, which, amongst other things, is going to introduce a presumption of employment for those workers that are caught by the Platform Workers Directive. But that needs a lot more. There's a long way to go at the moment between the text that we've got from the EU and what it might look like at a national level. So that's something that a lot of people in that area I know are looking closely at. It's also something that I think will see significant change here in the UK as well. The test for who's an employee and who isn't, because it's something that Labour identified at quite an early stage as being something that they wanted to look at in their first 100 days in office, as at the time of recording this podcast looks quite likely to happen after the upcoming election.
Yeah, absolutely. So what you're saying is Labour are talking about in their first 100 days, kind of looking at how they might revisit the testing for contractors and if they are a contractor or if they should be a full-time employee.
Exactly. Yeah, I mean, the proposals at the moment talk about a single status, which would remove that sort of subcategory I referred to very briefly earlier, create a brighter line between people who are employees and not employees, rather than this intermediate category we have of non-employed workers who get some but not all of the benefits of employees. That's easy to say, it's more difficult to do. So it'll be really interesting to see the detail of proposals that I expect will come out for consultation over the first few months. It could lead to, I mean, obviously it will be important for the platform economies. I think it will actually have a much broader implication as well, because they're not making rules specifically for that industry. They're making rules that will apply to all of us.
That's really interesting. And on those broader rules, how do you, and obviously in the last few years, there's been a huge rise in this work from home era, and I'm curious to get your take on how that affects things like classification of employees.
Yeah, I mean, I think it's sort of a double-edged sword, to be honest, because when people work from home and have less sort of classical employment relationships, so you're not leaving your house at 8:30 every morning, coming into the office for 9 to 5, and then going home. When they're doing something else, working a bit from home, a bit from elsewhere, it's up to them. Um, it's more difficult to monitor what they're doing for one thing, but it also gives them an opportunity that they didn't have in the classical employment environment to potentially do other things. So it gives them a more genuine opportunity to act as a contractor, for example, to say, I am providing, I don't know, marketing services to 3 or 4 different companies. I'm not just a 9 to 5 marketeer for company A. I'm doing this multiple companies. I'm an independent sort of marketing freelancer. That's possible in that working from home world. I haven't seen many people go from I'm an employee for this company to we're going to change to a contractor relationship and I'll do this more broadly. What I think you do see is people set themselves up in that frame who wouldn't have been able to do it before because they would have been tied to the 9 to 5 in-person attendance. So that's the positive. It creates opportunities. The negative is for companies is it's less easy to monitor. It's less easy to be sure what people are or aren't doing, and that creates a sort of further challenge for people. But I think by and large, it's an opportunity rather than a negative.
Yeah, yeah, absolutely. So what would be your kind of tips for avoiding misclassification? How can companies make sure they're ticking the right boxes? If they are in this kind of grey area, which you mentioned, there's a fair amount of grey in this area of the law. Like, what are the things they should be thinking about to make sure they're either firmly on one side or the other and not caught in the middle?
Yeah, well, I mean, a really basic thing to get right at the start is to get your terminology right and to not be calling your contractors or people that you are saying are contractors employees, not talking about their salary, to be precise in the language that you use, not to be treating them like employees, basically, so to be conscious about it. I think the other tip I think about is not assuming that it's fine. I spoke right at the start of this podcast about how a lot of the time it could well be fine because the relationship may end it may be a good breakup. But that's if you sort of assume that's going to happen, then the time when it doesn't will be all the more devastating. So, that's that old maxim about sort of hoping for the best but preparing for the worst. I think that applies here too. Finally, you might think about putting in place something I've worked on with several of my clients, which is a questionnaire which sort of flushes out the legal risk at hire. So at hire, you can ask the candidate or sort of would-be contractor to answer a series of questions that try to tease out some of those factors that we talked about earlier. You can also have a hiring manager answer the same questionnaire, more or less. And then as the sort of control person in the business, whether that's HR or legal or sort of more senior manager, can compare their answers and see whether how the contractor anticipates working aligns with how the hiring manager anticipates working, and then again how that measures up to the legal test that's applicable in the country. I suppose finally, typical for a lawyer to say, you should of course take legal advice on your classification issues as they come up. But I'm also realistic that no company's going to do that every single time it happens. So I think the more important thing is to put something in place that makes sure that hiring managers and HR have some guardrails themselves that they can access without needing to escalate.
Yeah, I think that makes total sense. In fact, I really like that that questionnaire idea, and then that gives you the process then to fall back on to say that this is how if we're ever going through a DD process or something like that, this is how we've classified everybody. But then also, I guess what you'd suggest is then having all of those documents, those questionnaires that the employees have filled in on file, so you've always got those records to fall back on, right? So let's say you find you do some of these questionnaires, you do some of this, you ask some of these questions, and you find that actually you've got some employees who are classified as contractors, and you need to then think about how you change the employment model. How would you think about handling some of those situations?
Yeah, so I think as ever, when you've identified a potential problem like this before panicking. I mean, don't panic ever, but you want to scope out the risk to work out what the potential financial exposure there is, because there's a big difference to thinking that, someone who works a few hours a week for you and in maybe a relatively low paid role is potentially misclassified versus your CTO. So you go back to that example. So I think it's worth thinking about the amount of salary or fees that this person is paying, and also what the local enforcement regime and consequences are there, so that you can try and get a bit of a ballpark figure. And that can also be really helpful internally, because sometimes people who haven't listened to this podcast are not as appreciative of the potential issues here. So being able to say, look, guys, we need to focus on this because this is a potential €1 million liability, can focus some minds. Equally, it gives you some credibility if you're able to say, this is something we need to talk about, but ultimately our exposure is limited to this, so it can be prioritized accordingly. So that's the first thing, scoping the risk. The second thing I think is working out what you want the future to be for those people, as in, not what happens to their hopes and dreams, but what do you want for them in the company? Are they a really important key hire to retain that you, such that, you couldn't lose them? Or are they someone who actually the financial risk, the misclassification risk is a problem, more of a problem than the idea of losing their services, because that's going to inform how you approach it. You might think about actually wearing some classification risk if it's a person where their contribution to the business and their insistence that they be classified in that way outweighs that risk. So you need to have both sides of that. And then once you've done that, I think the next stage is really sort of working out how you're going to deal with this, if at all, looking at the costs and practicalities of bringing these people onto payroll. That's one time when you might loop back to the employer of record solution that we spoke a little about earlier, which obviously Omnipresent is a key part of the marketplace for that. And just working out whether that is the best solution for them, what the individual attitude to that is, and also what the company's sort of negotiating position going into it is. And that's why the future point is so important for that, because you will be approaching the conversation quite differently if this is someone you cannot afford to lose a service of versus someone who actually the company putting more of an ultimatum to them, saying, we are terminating your contractor agreement. Here's an offer of employment if you want it.
Yeah, got you. I guess this can be that kind of situation can be quite a challenging one, not just for the employee, but for the employee as well, right? If you're going to have, let's say, a dozen people that you actually want to have some of these conversations with, that can create some anxiety for the employee, but also the employer knows about these risks. They know what could happen if things go wrong. So I guess what would your thoughts be, or guidance or advice be for people that are kind of embarking on some of these conversations?
So do you mean from the employer side or from the...
Yeah, from the employer side, yeah.
Yeah, I think there's a balance to be struck between being reassuring and making and depicting this as kind of business as usual, as a sort of tidy up, versus not giving the impression that this is big problem, or that the individual has done something wrong, or similarly that the individual has some significant point of power over the company here. So it depends quite heavily on the bargaining power, I'd say, and what the offer is from the company. Because, for example, we talked earlier about the fact that sometimes being a contractor can carry some tax advantages for the individual. So if you're coming in as an employer and you're saying, I want you to stop being a contractor that we're paying €40,000 to a year, but here's an offer of employment for €40,000 a year, is that going to mean less net salary each month for that person? And if so, is that a problem? Because there'll be other things they get as an employee that they might not have got as a contractor, like pension contributions and benefits and so on. So I think as an employer, you need to really put yourself in the shoes of the person on the other side of that conversation and work out if you are delivering good news or bad news? And if it is bad news, does it have to be bad news, or can we revisit that and all that? Because no one wants to break bad news if you can avoid it.
Yeah, absolutely. I think you're absolutely right to think about all of the different aspects of this that are going to impact the employee. One is, as you say, the take-home pay, but there's also the additional things they get, like the additional leave, holiday, other things like protections, pension contributions. I think that's a really important thing to factor in and use that, like put yourself in their shoes and what, give yourself a bit of empathy on that conversation. A few things you touched on are, like you mentioned, kind of like if there's a new Labour government in the coming weeks, they're probably going to create a brighter line between for these classification issues. Talked a bit about certain countries kind of like siding with the companies when it comes to some of those gig economy situations. And I'm curious to get your take on like, and you also mentioned like the EU legislation's coming out as well. I'm curious to get your perspective on, like, from a global perspective, which way is the wind blowing? Are we headed more towards protecting employees, or are we heading more towards like favoring businesses, or is it a bit of like everyone's doing their own thing?
Yeah, I think the general direction of travel, as much as you can sort of identify it, is towards greater employee protection and towards that tent of employees getting larger rather than smaller. I think I can't think offhand of a country that's shrinking, the definition of an employee. However, with that said, I think the focus is much more on the platform economy and sort of what are sometimes referred to as dependent contractors, people who are classified as self-employed but are in effect working solely for one client, and where that client has all of the bargaining power. An example might be working as a delivery driver for a major logistics company, and they say, "You're not our employee, you're a contractor, take it or leave it." And you're not really in a position to, tell them that your lawyer will be back to them with a markup of the terms, because that's just not the reality of the relationship. So I think the focus is much more at that end of the scale than on, to go back to the example, the CTO in his holiday home in Cyprus. The question is, when those rules are drawn up, when those new laws come into effect, do they sweep in the sort of moneyed CTO together with the platform worker in Barcelona and lift them both up and provide them with the same level of entitlements? But in my mind, the policy focus is very much on the delivery driver rather than the CTO. The unknown, how the changes affect both.
Yeah, makes a lot of sense. Okay, just a couple more questions from me, and then so, in terms of the lawmakers, is there any advice you would be pointing in that direction? Like how can what suggestions would you have for them to make your lives easier and the lives of your clients easier?
Yeah, well, I mean, the truth is, it just is quite a difficult area, right? We're trying to draw a bright line on territory that is gradient. The truth is, there's not something that 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 any one person can point to produces this really clear distinction. And that's why this has been a field that's been ripe for litigation, challenge, and compliance issues. So I don't think, not to be too defensive of any individual government, but I don't think there was an easy answer here that the governments have been missing. The first words that often come out of any lawyer's mouth when you ask them to advise about whether a particular person is a self-employed or not, is it's a very fact-sensitive issue. And I've got some sympathy with that, because it is difficult. But that said, what we've seen mostly in recent years, certainly in the UK, but also elsewhere, is that there's been a real inaction on the part of governments. They've kind of made rules in some cases sort of 10, 20, 30 years ago, and they've just sort of hoped for the best in terms of those rules meeting reality. And unsurprisingly, the reality now is a bit different to the reality 30 years ago. And employers are left trying to, force a round peg into, or a square peg into a round hole. I think the inactivity is maybe worse. And I think actually a renewed policy focus on this area, while it might produce some unwelcome results, TBC, could actually produce some welcome greater clarity. That's what I hope.
Yeah, absolutely. Yeah, it's hard to think back to like 10, 20 years ago with like how much had changed, not just the gig economy, but things like social media and all of these kind of different situations. Like there's a huge amount that probably needs to be updated from a government perspective. Cool. So to finish off, Raoul, it's been really great to have you here, but I'm curious to just finish off with what would your key takeaways be for any business right now that might have a global workforce and they're thinking about some of these topics that we've talked about?
Yeah. Well, yeah, my three tips I think are: number one, don't assume it's easy. We've spent I don't know how long exactly talking about this issue now, and I feel like we're just sort of scratching the surface. It's not straightforward. There will be nuances, there will be shades of grey. So this is something that will require a bit of engagement and a bit of investment. Going to get it right. Number two is work out your risk tolerance, because this is an area in which it's the only way to take zero risk is to insist that everyone's an employee. But A, that's very expensive. B, it's not practical because lots of people don't want to be employees. So you'll lose out on talent if you do that. So you have to work out your risk tolerance somewhere between everyone must be an employee to anyone can be a contractor, and where you're going to be along that line. And the third is knowing your people. Don't necessarily mean knowing them well and knowing sort of how many children they've got and their names, although that's probably a good idea too. I mean, knowing who you've got and what they're doing for you and where they're supposed to be doing it, because that's often the way these misclassification issues come to light or worsen, is because there's a contractor doing a particular task in a particular country without very much oversight, who's kind of fallen under the radar for a little while, and then the termination decision is made, and then suddenly we've got a problem. So yeah, those are the three tips. Don't assume it's easy. Work out your risk tolerance and know your people.
Makes a lot of sense. Well, it's been great to speak to you today. I really appreciate all your insights. I've certainly learned a lot, and yeah, thank you so much for being on the podcast.
Yeah, great to talk to you, George.